The third and last case for this afternoon is Rice et al. Versus Grubbs, case number S06A2024. Okay, we are ready when you are. Yes, yes.
Ready.
Good afternoon. May it please the court, I'm here this morning representing the appellants. My name is Kathryn Taffy Rice. This is a writ of prohibition matter against Judge Adele Grubbs. It is an issue that was raised based upon bias and prejudice. There were multiple recusals and multiple efforts to redress the issue in a manner that was not such an extreme remedy. However, they were unsuccessful and the bias and prejudice simply escalated. In that regard, it is very difficult, may I say, to come before anybody, particularly a panel of judges, and address the actions of another judge. That is to say, a Board of Governors member for the Georgia Bar Association, a recipient of the Justice Benham Award, and also with regard to the discussions that have taken place at the Governor's office during Justice Melton's tenure as counsel to the Governor. So with that in mind, I proceed as a sui juris litigant, not legally trained, in an effort to provide the evidence as I understood it. The previous gentleman said that a lie is a lie, and it's offensive, whether it's unconstitutional, regardless of the basis in law. And specifically, I could not concur more vehemently. That is to say, the underlying case, the writ of prohibition, is again solely based on bias and prejudice actions by Judge Adele Grubbs. However, in the brief provided by the Attorney General for the state of Georgia, the issue of previous cases was included, and the suggestion that the writ of prohibition was simply used as a vehicle to relitigate other issues was made. Let me state for the record very clearly, in the appellant's brief, there is absolutely no reference to the merits of a case, LMHA and the ACC of LMTHA v. Rice. However, that case has clearly had a rippling effect. There can be no question. There were additional cases filed based on specifics that came out of that case that were unrelated. And the sole manner that I would like to address the brief provided by the Attorney General is to note that there are absolute unequivocal errors. In the first page of the statement of the case, the caption of the case alone is incorrect. The case was not only Lost Mountain Homeowners Association, it also included an ACC of LMTHA, LMTHA being a corporation owned by Kathryn and J. Andrew Rice. Let me assure this body we did not sue ourselves. LMHA being a dissolved corporation at that time, it is stated in the brief by the Attorney General that we were sued by our homeowners. Let me assure this body that the deed to my property has no homeowners association and no covenants. It is an unencumbered deed, and therefore I do not possess a homeowners. It also states that I had an 11-foot fence, which of course the county has provided sworn affidavits. I did not. Mr. Ronald Cannon sold property under the name of the president of LMTA. However, he filed suit against the Rices as the president of LMHA. It can't be both, and certainly in his sworn statement to Judge Grubbs, he was very specific that he had only and always been president of LMHA. Therein lies false statements made and a subsequent lawsuit against Mr. Cannon, not as the president of any alleged corporation, not a dissolved corporation, and certainly not one that he himself had attested not to represent. However, noted here is that the writ of prohibition relitigated cases. It is stated that it is solely a second and duplicative action. However, there is no mention of these factors in our writ of prohibition as you read that document. There is no mention of an 11-foot fence. There is no mention of Ronald Cannon. There is no mention of any things that the Attorney General has raised, not the Rices. In addition, it notes that the Rices did file a federal lawsuit against Judge Adele Grubbs. That is true. The Attorney General also represented Judge Grubbs in that matter and did not bother to provide service of any responses or answers to the Rices, clearly in violation of the rules of the court. The writ of prohibition is based solely upon the actions of Judge Grubbs in showing bias and prejudice, and the larger issue which came from it, the actions of Judge Arthur Fudger. In a hearing before Judge George Krieger, a personal friend of Judge Grubbs, to whom the writ of prohibition was assigned, the argument was predicated upon a motion to dismiss tendered by the Georgia Attorney General's office. That case was clearly argued, and from it, the Rices asserted JQC 220, a bright line rule, indicating that action against one judge, no other judge within the circuit could sit as an unbiased trier of fact over the matter. Clearly, there needed to be an assignment of a judge outside the court, and Judge Krieger did make that assignment. That is to say, he rendered an order clearly calling for another judge outside the Cobb Circuit to be assigned. Unfortunately, however, what transpired is no less than not just bias and prejudice, but literal fraud and racketeering within the court. Understanding that that is a weighty statement and not wishing to be associated or part of such an accusation, let me demonstrate that while Judge Krieger clearly, as tendered on the document May 26, 05, orders that, according to JQC 220, a judge must be assigned outside the circuit, the unfortunate matter and fact is that there never was an assignment of a judge properly tendered, not in the court record and not made known to the Rices, clearly in violation of the rules of the court. Judge Fudger's assignment was made known to the Rices upon his dismissal of the writ of prohibition. The court record showing the writ of prohibition matter lists all the documents that were contained in that file. And there is also a statement that has been included by Ms. Lisa Thrash demonstrating that at the time of Judge Fudger's order dismissing the action, he had never in fact been assigned. As a result, there was a motion to declare order void tendered to address the action. That is to say, Judge Fudger's void order, which clearly could not, as a matter of law, bear weight, having never been assigned to a matter, or such being presented to the plaintiff. However, following the emergency hearing that was refused by the senior judges of the Cobb panel, would not even hear it. An emergency motion was also tendered to Judge Krieger, the last judge who possessed jurisdiction over the matter. In doing so, a hearing was scheduled. A Rule nisi was issued, and just prior to the hearing, there were a number of documents that were evidently created. And therein lies the issue of fraud and racketeering specifically. These documents, following the filing of an emergency motion to Judge Krieger, were tendered in the court record. According to Judge Krieger, they were tendered into the subject writ of prohibition, which was civil action number CAN 051-043718. However, the Rices, upon visiting the court records, found no entry of any additional documents of assignment prior to the hearing with Judge Krieger. Upon entering the courtroom with Judge Krieger, we were informed that most certainly Judge Fudger had been appropriately assigned and Judge Krieger possessed that document. He threw the document at me from the bench and instructed me to leave his courtroom. The document that Judge Krieger provided is now noted here, and the specific case number in the upper left corner, it is titled, the document title is Order of Appointment of Judge. The document is titled, with case number in the upper left corner, 05-1-0002, which again is not the case file 05-1-0437-18 of the subject writ. Therefore, not only was the document not filed, but worse yet, on the bottom of the document is noted a fax transmission. And the fax transmission indicates that this document was provided to the Cobb County Courts the night before the hearing at 8:44. So not only did it not appear in the writ of prohibition matter, as Judge Krieger asserted, but it clearly did not exist in the court record beknownst to anyone prior to 8:44. Subsequent to the creation of this document provided by Judge Krieger, the Cobb Courts, the clerk's office, J. Stevenson, created multiple versions. If you notice on this version, there is the Elisa Thatch certification at the bottom, but no fax footer, as in the document provided by Judge Krieger. And upon discussing the matter further with the clerk's office, there even yielded a third copy of the document, being the same order of appointment of judge. Again, no fax footer, and this time not even certified by Ms. Thatch, but rather Steve Fox. So 3 different versions of an order appointing a judge made after the judge had issued an order dismissing the subject writ. Clearly, the judge acted outside his jurisdiction. And what was even more telling, beyond the 3 versions of the document, the alterations, was that in the document asserted by Judge Krieger, it states that Judge John Bolin Wood of the 7th Judicial District signed the order first on May 3rd, which is scratched out, not redacted, but simply stricken through, and he replaced it with June 3rd. Interesting. So now we have the document being faxed on 8/10, but yet he was allegedly at best assigned June 3rd. And yet when Judge Krieger wrote his order, he indicates that he was assigned June 13th. So on the face of the documents alone, we don't seem to have a consistent concurrence on when Judge Fudger thought about being assigned. But without regard to his thoughts or the assertions, clearly in violation of the rules of the court, there was no assignment of Judge Arthur Fudger in the writ of prohibition against Judge Adele Grubbs. Something absolutely startling came from the plethora of documents that preceded that I have covered. One was a document from Ms. Rebecca Mick of the Georgia AG's office, in which she immediately, upon the July 7th order of Judge Arthur Fudger, wrote a letter to Ms. Dorothy Bishop, the county attorney for Cobb County, asking for a motion to dismiss and attorney's fees. While she had only asserted attorney fees based on speculative what she might make if she didn't work for the Georgia Attorney General's office, she wanted to be paid. And there is the mention of contempt if the Rices do not abide by this request made from the Attorney General. Again, sent not to the Rices, but to County Attorney Dorothy Bishop. Strange at best. I would assert that this is an attempt for shuffling of paper and racketeering and fraud to take place. In addition to the actions by the Georgia Attorney General of July 7th, we also have the subsequent actions of Judge Grubbs herself. On July 8th, Judge Grubbs was very busy. She immediately ordered a hearing on contempt and also defendant's motion to dismiss, based solely upon the actions of Judge Arthur Fudger. Heretofore, Judge Grubbs had acknowledged that based on the writ of prohibition, she could not take actions and therefore was barred. However, upon the publication of the plethora of information and the order by Judge Fudger, it would seem that Judge Grubbs felt empowered to begin a litany of acts against the Rices, dismissing every case before the Cobb County courts, one of which against Ronald Cannon personally had come before Chief Judge Jim Bodiford. Chief Judge Jim Bodiford not only scheduled a special set hearing, but being made aware that there was a federal lawsuit against Judge Grubbs, transferred the Cannon case to Judge Grubbs. Clearly not an act of a person who understands bias and prejudice. So as we stand this afternoon, ladies and gentlemen, our goal is to demonstrate that certainly the Georgia courts are not run in any less than the rules of the court, the Georgia Code, and the constitutions, both of this state and of this country. But clearly, the falsification of documents, the dismissal of writ of prohibitions, the plethora of documents to cover, to create a facade, to dismiss any worthy effort towards due process cannot be condoned, cannot be allowed, and is certainly not what our state nor this country can be known for. The illegal ex parte communications, getting back to the writ of prohibition and not the onset or the after effects, was based upon a conversation Judge Grubbs engaged in. The conversation occurred at the Chamber of Commerce, the Cobb Chamber of Commerce. It was conveyed to the Rices and their neighbors by District Attorney Pat Head. It was noted, affidavits were obtained and filed. Clearly there was an opportunity for Judge Grubbs to abide by her self-recusing mandate, as Canon 3B notes. However, it is not and should not be any litigant's responsibility to instruct a judge in their responsibilities. Certainly we are not trained and it is not our position. However, the illegal and ex parte communications only manifested into a continued bias. And without question, the requirement of faithful execution of the law never came into play, nor was equal protection of the law afforded to the Rices, nor their due process rights. Without regard to the self-enforcing Canon 3B, the abuse of power and the malicious prosecution that took place and followed could not have occurred if a responsible use of evidence had been considered in the underlying case. If proper proceedings had been held in accordance with the rules of the court, there would be no need for a writ of prohibition. Certainly in raising 3 children and 2 properties, we have no desire. I come before you as a sui juris litigant, and in some of the pleadings you will find the misfortunate notation of pro se, not knowing the difference at the time that we filed given pleadings. We are not legally trained. However, we do understand our rights, and we do understand the fundamental tenets for both the state of Georgia and the United States judicial system. This is without question a due process travesty, and it is not alone. There are many in Cobb County, unfortunately. There are websites that talk about scams with regard to seniors relating to Judge Grubbs. There are also wrongful incarcerations with regard to money judgments. However, in the writ of prohibition, this sole matter is predicated upon the bias and the prejudice of Judge Grubbs against the Rices. The 3 different versions of the order to assign Fudger, the discrepancies between Fudger's order and his lack of addressing one matter noted in the writ of prohibition, the suggestion of relitigation by both the Attorney General and Judge Fudger, not found in the writ of prohibition, however repeatedly known by connected parties. It has to say loud and clear that there is no due process and that it certainly wasn't available in Judge Grubbs' court. Thus, there is no question that this body must, in an effort to restore lawlessness, lawful behavior and correct the lawlessness of Cobb County, must nullify Judge Fudger's order rendered in the absence of jurisdiction. If Cobb County wanted to properly adjudicate the writ of prohibition, they had every opportunity. At the time we stood before Judge Krieger, we were not aware that he was officiating weddings for Judge Grubbs. We were not aware that he was close personal friends. However, it is incumbent that the rule of law be protected, and the only issue is whether the bias affected Judge Grubbs. Without question, the multiple calls for contempt, the calls for the arrest of the Rices when they sought assistance from the U.S. Attorney, when they ran for political office, there can be no question that bias has been overwhelmingly imposed here. In even the pleadings by the Attorney General in the Cannon case, it is noted that the Rices cases were frivolous, referring last to the Cannon case. At the time the Attorney General authored that brief, there had been no rulings in the Cannon case. There had been no hearings. However, Judge Grubbs had conveyed to the Attorney General, obviously, that the Cannon case was frivolous without any possible adjudication or due process being afforded. In addition, the discussions, as previously mentioned in the writ of prohibition, both at the Chamber of Commerce, from which Judge Grubbs received the Citizen of the Year Award following her actions against the Rices, but in addition, comments made in the Marietta Country Club that were attested to, and also luncheons where attorneys were invited and discussions of the Rices' publications regarding the travesty were discussed.
Ms. Rice, let me ask you one question. You mentioned earlier interactions with the governor's office. To your knowledge, have you and I ever had any conversations or communications about any of these matters?
I remember specifically you having an assistant contact me and not speaking to me directly. However, you were given 337 pages of evidence attesting to fraud, and the repeat back from your assistant was that it was a separation of powers issue. Specifically, the only issue currently today is, does the defendant harbor a bias against the Rices, which stripped her of her jurisdiction, in addition to the lack of assignment of Judge Fudger, which obviously negates any alleged assertion that there ever existed jurisdiction, Judge Fudger being a Paulding County judge, not a Cobb County judge. So therefore, an assignment was only proper and required as a rule of the court. Objections were repeatedly made with regard to these actions. You can see recusals, you can see motion to declare order void, you can see emergency motions all contained in the record, and at no point...
Thank you very much. Your time is up.
May it please the Court, my name is Ann Brumbaugh. I'm an Assistant Attorney General. I represent Judge Adele Grubbs, who is the appellee in this case. She is of the Cobb County Superior Court. I'll try to take Ms. Rice's contentions one by one. The first is her issue that bias and prejudice underlie her writ of prohibition. Bias and prejudice are not appropriate reasons to file a writ of prohibition. A writ of prohibition is an extraordinary remedy that is only available when a judge has exceeded her authority and when there is no other legal remedy available to prevent the judge from exceeding that authority.
Has there ever been just a simple motion to recuse in this case?
There has been, well, there have been several in the underlying cases. As I understand it, there were 2 motions to recuse or in the alternative to disqualify Judge Grubbs filed in the Rice v. Cannon case. There were 2 motions to recuse or disqualify Judge Grubbs in the Lost Mountain Homeowners Association versus Rice case. All of those motions to recuse were denied by Judge Grubbs. When Judge Grubbs sided with the Lost Mountain Homeowners Association, the Rices appealed that decision to the Court of Appeals. In their briefs to the Court of Appeals, they did not appeal Judge Grubbs' denial of their motion to recuse in that case. They have never sought an interlocutory appeal to appeal the Rice v. Cannon motions to recuse. Instead, what they did when they realized that the Court of Appeals opinion was coming back to Judge Grubbs to enter an order, and when their motions to recuse in Rice v. Cannon had been denied, they filed this writ of prohibition in January of 2005, alleging, again, bias and prejudice, subjects that are worthy of a motion to recuse but are not appropriate for a writ of prohibition. Judge Fudger was correct as a matter of law in dismissing the writ of prohibition against Judge Grubbs in this case. Turning to the transfer from Judge Krieger to Judge Fudger. There is no fraud in this case. There's no racketeering. It is true that the order, the designation order, was never entered in the Rice v. Grubbs file, that is file number 05-1-0437-18. But as I put, this is record page 298, as I put this up on the screen, you can see in the upper right-hand corner, it says filed in the office June 13, 2005, and it gives the minutes designation, the minutes for the Cobb County Superior Clerk designation. That is all that a designation order is required to do. Designation orders, the conferring of jurisdiction from a Cobb County judge to, say, a Paulding County judge, are governed by statute OCGA 15-1-9.1, specifically subsection F. And it requires that the designation order state the county, the court, the specific case, the time period, and the reason the assistance is needed. This designation order gives you the county, the court, the case, and the time period. There is a typo in that it says the reason the assistance is needed is a motion to recuse Judge Ingram, and both sides would agree there's no motion to recuse Judge Ingram in this case. However, Judge Fudger received this order, looked at his file, which had a petition for writ of prohibition and a motion to dismiss a writ of prohibition, and ruled on the correct issue, which was the writ of prohibition. Finally, the statute requires that the designation order shall be filed and recorded on the minutes of the clerk of the court requesting assistance. That is what it takes to confer jurisdiction from one county to a judge in another county. And that is what was done here. As you can see, it was filed in the minutes of the Cobb Superior Court. There's no requirement that a designation order be filed in a specific case file. Now, Ms. Rice claimed that she had been subject of a due process travesty, and I would respectfully disagree with her. There's been no due process violation in this case. The Rices themselves requested the transfer, as Ms. Rice stated. They were the ones that brought the Judicial Qualifications Council opinion to the attention of Judge Krieger, and the Court of Appeals opinion following that opinion, which says it's a bright line rule that cases of this nature be transferred to a judge not in the same county or on the same bench. So they requested this transfer both orally and in their writ of prohibition. Secondly, this is that same Judge Krieger order. This is at pages 195 and 196 of your record. And as you can see at page 196, they received service. They received notice that this order had been sent to the 7th District Administrative Judge requesting a transfer to a different judge. So they knew they were going to get a different judge. They were on notice of that. They don't get to pick the judge they get ahead of time. There's no right to that, there's no guarantee to that, there's no statute. You get the judge that's assigned to you. If you believe that bias and prejudice exists with that judge, you file a motion to recuse. That is the way the procedure works. So there was no travesty involved in the transfer of this case from Judge Krieger to Judge Fudger. Judge Fudger did have jurisdiction pursuant to 15-1-9.1F, and Judge Fudger did come to the right decision because the reasons that the Rices have consistently alleged for their writ of prohibition simply are not appropriate reasons to file a writ of prohibition. Moving on just briefly, there is the issue of attorney's fees. There was no evidentiary hearing in this case before Judge Fudger ordered the fees, and the Attorney General and Judge Grubbs would agree that this case should be remanded for an evidentiary hearing on the attorney's fees. If there are no further questions, thank you very much.
Thank you very much. This court is adjourned. No, I'm sorry, your time was up, ma'am. Thank you.
Thank you.